Fund your trust, fund your trust, fund your trust. I can't say it enough. A recent case provides a specific object lesson for anyone in a second marriage who has either a trust separate from their spouse or who has retained their original trust upon remarriage. But it also offers a general lesson to everyone who has a trust. The reason we deploy and fund trusts is to avoid probate. Once probate is involved, things get very complicated. The details after the introduction. Good day. I hope you are all well. Only a properly and completely funded trust protects your estate planning choices. A pour-over will does not magically repose assets or property in your trust upon your death. It must be probated if assets are out of your trust. Probate means risk, costs, and expense. A pour-over will is subject to the same limitations, requirements, risks, and rewards as a will created when there is not a trust, including spousal claims. And that's going to be the subject of the case we're going to talk about. A Montana Supreme Court recently held that a widow could claim a spousal elective share of the deceased husband's estate, notwithstanding that her deceased husband's will directed everything to his trust. Important for married couples with separate trusts and or second marriage, certainly, but as I walk through the case, pay attention to how complicated this case becomes once it gets into the probate court. The facts of this particular case are that Carol Tokowitz was married to her husband, Neil Tokowitz, for 30 years before he died. Her husband left behind surviving children from a previous marriage. He had a pour-over will that funded a revocable living trust. His will did not name his wife or anyone else as a beneficiary. It only named the trust as a beneficiary. By the way, as far as the will is concerned, that means that Neil Tokowitz disinherited his spouse. After her husband's executor, Mr. Silverwood, and I'm just going to refer to Mr. Silverwood and the executor as Mr. Tokowitz's family from here on out, because that better explains kind of what's happening. Mr. Tokowitz's family filed a petition to probate the will. Mrs. Tokowitz asserted her right to an elective share of her late husband's estate under the Wyoming spousal elective share statute. So you probably have already, if you're paying very close attention, you may have already picked up on two very important complications. The first is, what is an elective share? And the second is, since this is a Montana case, why in the world are we even talking about a Wyoming spousal elective share? How does that happen? Mr. Tokowitz's family, just to understand what actually is happening here, was arguing that Mrs. Tokowitz was not entitled to a spousal elective share and taking more of the total percentage of the estate than was provided for her by the trust. And that was the real issue. It appears that Mr. Tokowitz's family was willing to pay Mrs. Tokowitz her share from the trust, but once that total share was determined, they didn't believe that she should receive anything else. And of course, she was making a claim for an elective share, a percentage of what was in the probate estate, and she would also get a share of that once it came through the trust. She was actually getting a higher percentage than Mr. Tokowitz was actually afforded her in the trust she created. The probate court granted the spousal share and declined to rule on her interests in the trust, and the family appealed. And that's how we get to the appellate court. Now, the highest court reviewed the case on a couple of different grounds, but I kind of want to go through each of these so that you understand the complications. The Wyoming spousal elective share statute provides that a married person that is domiciled in that state must provide a spouse at least an elective share subject to distribution in the will. An elective share is not uncommon. Most states have them. Most states, by policy, provide that one spouse cannot completely and utterly disinherit another spouse. And in order to prevent that, the law generally provides a spouse a right to elect or take against assets in a will. So if a will, such as a pour-over will, doesn't provide a share to the spouse is entitled to elect or take against that will. If, as in this case, the surviving spouse is not a parent of the decedent's surviving children under Wyoming law, the elective share is 25% of the entire state. And you can kind of understand how this is happening as far as Mr. Tokowitz's family is concerned, because she's getting 25% of whatever is in the probate estate, then whatever's left, the 75%, is going into the trust, and then she's getting another percentage of that according to the trust. The executor and the trustee argued that although Mr. Tokowitz was a Wyoming resident, he was not domiciled in Wyoming full time. The petition to probate the will, though, stated that he was a resident of Park County, Wyoming, and the pour-over will stated that he was domiciled there. In other words, just to make this simple, he created a will in Wyoming back when he created his trust, and the Wyoming will said, I'm a domicile of Wyoming. The probate court implied that he was domiciled in Wyoming when it decided that it was using the Wyoming statute to determine the surviving spouse's elective share. So what is the difference between a residence and a domicile? A domicile is a legal residence where a person intends to stay. It is your permanent place. A person can have many residences, but only one domicile. I'm a good example. I actually have two residences, but I have only one domicile that is my permanent residence. As the will presents evidence that the decedent's domicile was Wyoming, Mrs. Tokowitz met her burden of establishing a Wyoming domicile and application of the Wyoming law. The burden then shifted to the personal representative and the trustee, in other words, Mr. Tokowitz's family, and they failed to show that Mr. Tokowitz was domiciled elsewhere. I don't know whether they overlooked it. I don't know whether they didn't have any evidence, but the bottom line is that's how we get an elective share from Wyoming in a Montana case. The executor and the trustee's next argument concerned the amount that Mrs. Tokowitz would receive under the trust. They asserted that the court should not give her the elective share because it did not know whether she would receive more or less than a quarter of the estate under the trust. The trust terms, according to the court, though, were irrelevant. The spousal elective share statute solely pertains to the will and assets that pass through probate. Mr. Tokowitz's will only left his property to his trust and did not name his wife, which effectively entitles her to the spousal elective share under the statute. And this is undeniable. Finally, Mr. Tokowitz's family claimed that the property was not subject to probate because the will poured over into the trust. This is a common misconception, and I'm actually kind of shocked that this argument was actually not only made at court, but was brought up to the Court of Appeals. The argument is that since I've got a trust and I've got a pour-over will, that the property just magically gets into the trust and doesn't need to be probated. But that's clearly not true. Property that passes by way of a pour-over will is part of what is the probate estate, and it is subject to the spousal elective share. Assets that transfer through a pour-over will are not exempt from all of the laws, regulations, procedures, risks, expenses of the probate estate. A pour-over will is not ever to be seen as a means of funding your trust. It is a safety net. In other words, the reason I prepare a pour-over will for my clients is because there are situations in which we may want to go to probate court. There are situations in which we may have to go to probate court. And having a will, any will, is better than having no will at all. If I have a will, I can get to probate court if, for example, I need to file a wrongful death claim, and I ensure that I have the right person nominated as an executor. But most importantly, I relieve the estate of bonding requirements that otherwise might increase the cost of the probate estate. Having the will reduces the cost and expense of any probate estate. So if I have to have one, or my family or my clients want to have one in probate estate for whatever reason, I have a way of doing that inexpensively. And finally, it is a safety net if things are accidentally left out of the trust, but it should only be seen as a safety net. In other words, there should be no significant asset that should just tumble out of your trust and then find its way into your probate estate. If you have funded your trust properly, it would be only a minor asset that is in the probate estate and, of course, minor risk. So the argument that Mr. Tokowitz's family made that property was not subject to probate was ridiculous. And the fact that the probate court even had to deal with it, like I said, I'm a little bit shocked about. The bottom line was that the appellate court held that Mrs. Tokowitz was entitled to her spousal share because that's the law. Once the assets pass to the trust, they become non-probate assets. There was no case law or statutory authority that supported a probate court ruling on non-probate assets. And so whatever the trust said, it said. And the Supreme Court of Montana held that the lower court correctly allowed her to take her spousal share and that it lacked jurisdiction to make any other claims, to rule on any other claims arising from the trust. Now, this particular case isn't over, though, because once the probate administration is done, those assets will pass to the trust. And I'm sure that there's going to be some argument that assets would have to be redistributed in order to reduce the amount of Mrs. Tokowitz's share in order to ensure that she doesn't get more than the percentage provided by the trust. And if that's done without any authority in the trust, there's going to be another fight. And there may be a fight even if there is authority in the trust to provide for that renormalization or redistribution or reallocation. My trusts generally don't have that type of provision in it. And I'll be honest with you that the biggest reason that I don't put those provisions in with regard to spouses is because they do offer opportunities for spouses to abuse those provisions. And I'm not going to go into a whole bunch of examples, but because of that risk, we generally don't include them. But we do always make sure that clients that have separate trusts, or clients that, if I have a client that has a trust separate from a spouse and I don't represent that spouse, I ensure that the trust has a provision that makes sure that the spouse gets what he or she is supposed to and nothing more. The most common place that you see in my trust that type of reallocation distribution is with regard to gifts or transfers that are made particularly within the first year prior to death, because there are a number of situations where family members will transfer assets to a son or a daughter when health is failing or there is emergencies, and not be cognizant of the fact that transferring those assets out of the trust to that particular child, while it might make those assets more manageable, it might be easier for the child in that particularly stressful moment, that those assets aren't then subject to the trust estate. And those assets unfortunately, are the property of that particular child. And sometimes that does harm to an estate. So in most of my trusts, I have a provision that provides that if there have been those types of transfers within the year immediately prior to death, that the trustee can reallocate assets to basically accommodate the assets that are going to a child as a result of those transfers, so that we're not getting a child who has benefited from those transfers. Oftentimes, that's not the intention of the transfer. And oftentimes, even when those transfers are made, the children will, either put those assets back in the trust or are happy to acknowledge that they don't get those in addition to their share under the trust. But as you can probably imagine, there are times where those situations arise. So bottom line, fund your trust, fund your trust, fund your trust. If your trust is not completely and fully funded, you may go through probate. Probate is costly, it's expensive, it is going to be a magical mystery tour, because that's what the legal process is these days. No one can tell you how it's going to go. No one can tell you what the arguments are going to be. No one can tell you how a court is going to look at any particular situation with specificity and assurance. And so you're in a magical mystery tour world. The trust tries to relieve you of that journey. So use the trust. I hope you liked this video. If you did, please subscribe, choose to like it, and share it with your friends and your family. I do want to thank you very much for watching. Stay safe, be well, and God bless you.